All right, Mr. Mims, I need to hear from you, sir, with the state recommending a null pros of count 1. It would be a plea of guilty to count 2, aggravated assault, and count 3, criminal trespass, if you so desired. So what is your plea to count 2, aggravated assault, and count 3, criminal trespass?
Plead guilty, Your Honor.
I accept your guilty plea. I do find there's a factual basis to support the plea, and that you're entering today's plea freely and voluntarily with full knowledge of your rights and those you waive in entering that plea. My sentence will be count 1 will be null pros. Counts 2 and 3 will run concurrent. It's going to be as the state has recommended. It's going to be 10 years to serve 5 years, balance of 5 years on probation, conditions of probation, family violence intervention program that must be completed within your first 6 months of release. No contact with the victim, count 3, 12 months concurrent to serve. Violations can be handled through POM up to the full extent of the law. On the probation revocation, I'll run it concurrent. It's 19 SC 167826. Balance is revoked to run concurrent with today's conviction. Violations can be handled through POM up to the full extent of the law. Anything else for the state?
No, Your Honor.
5 years, man.
Anything else for defense?
Shit.
Hold on, ma'am.
Oh.
All right, we're off the record.
Your Honor,
Yes?
what was the sentence?
He just needs some clarity, Judge. He was not understanding.
The sentence was as the state recommended. The 10 years to serve 5, balance of 5 years on probation for count 2. Count 3 is 12 months to serve concurrent. So it's a total of the 10 to do 5. You get credit for the time you served in custody. You have to serve the balance of the 5 years. And then after that, you'll have 5 years of probation. Do you want Mr. Hudson to call you?
Yes. Yes, Judge.
All right, well, you can take him back. I'll tell Mr. Hudson to reach out to you. Reach out. Okay.
Your Honor, I will also request if Mr. Hudson can please forward his contact or his uncle's contact number to Ms. Little so I can have the information for probation reference.
Contact information for probation, okay? Anything else today for you, Mr. Hudson? All right, you can be excused.
Hey, Judge, because
He can go back. Mr. Hudson's gonna call him now. So we can bring up the next person, please.
I can't hear nothing.
All right, who's the next person you have?
Mr. Gilbert, is his attorney gonna call on the line?
Not on the Zoom call. He's gonna reach out separately to him.
Okay, and he does have the number, right? 613.
I think he already got it from you. Doesn't he have it? Yeah. Do you have Mr. Thornton?
Mr. Thornton. This is Mr. Thornton.
Hey, good afternoon, Mr. Thornton. Can you hear me?
Ma'am, how you doing today?
I'm doing just fine. Thank you. We have your counsel. Do you see him, Mr. Howard? Can you speak up?
Ma'am, I can see.
I'm right here, Mr. Thornton.
All right, Mr. Thornton, can you see your attorney on the screen in front of you?
Yes, ma'am.
All right, so we also have in court with us today, Mr. Abadi for the state. Do you see Mr. Abadi on the screen in front of you? He's waving to you.
Okay.
All right. And the other lady on the screen is the probation officer, Ms. Brown, okay? So I have today, you on our calendar as the state has a couple of times requested an extension of discovery deadlines. So I just signed the first order when it came through requesting an extension back in January. I extended the deadline for discovery to, I guess, February 1st. And then I subsequently got the state's renewed motion. So just wanted to have you tell the court what's transpired, why you're needing an additional extension, and just tell me the due diligence that state's been exercising to get what you need, what's outstanding. Just explain it to me, and then I'll hear from the defense.
Yes, ma'am.
Since the first filing for an extension back in January, the last meeting, and photographs from the medical examiner's office.
Judge, I'm sorry, I can't really hear him.
No, you're fine. Thank you for letting us know that. Try again, speaking nice and loud into the microphone.
Since the first report that was, or excuse me, the first that was filed by the state has been able to turn over all the remaining outstanding discovery from the medical examiner's office.
Judge, I really can't hear him at all. I can hear something about medical, and then he's out. So.
Okay. Do you mind?
No, I don't.
Okay. He's gonna. All right. He's vaccinated, so he's unmasked. So we're gonna try it again. And you're not irritating me at all. You need to hear. So,
Okay.
Mr. Howard, please raise your hand if you can't hear him.
Okay.
And we'll stop.
Since the first filing for an extension, the state was able to complete all of the discovery from the medical examiner's office, including the full report, as well as all the photographs that were taken of the victim during the autopsy. We were also to get the firearms report for the testing of all the ballistics that were recovered at the scene, and that was turned over as well. What the state is still out, or what is still outstanding, Your Honor, signed search warrants for buccal swab of the defendant, Mr. Thornton. That will be compared if they're compared to the DNA that was actually taken from the phone that was remained on the scene. That the DNA that was found will then be buccal swab as supposed to be done today. I believe this afternoon. In addition, Your Honor, what remained outstanding is the phone that I was just speaking of was located at the scene. South Fulton Police Department attempted 2 times to dump the phone. Due to technology difficulties, they were unable to. But while speaking with the GBI most recently, we described the issue that South Fulton was having, and they feel confident that they have the software due to some updates that they'd be able to dump the cell phone. The state's requesting 45 to 60 days to get all of that done. The comparison of the buccal swab, the DNA recovered from the phone from the scene, and then the actual extraction from the cell phone that we recovered at the scene. And after speaking with the GBI, they're confident that they can expedite it and need no more than 60 days.
All right, Mr. Howard. So in summary, Mr. Abadi's requested 60 days to obtain the buccal swab of your client that he expects to happen today. The search warrant I signed, I think, sometime last week. And to do the DNA comparison with DNA recovered from the phone, allegedly from the scene. And then the GBI dumping the phone. So let me hear any response you may want to give.
Well, Judge, I understand what he's saying, and this has been going on for quite some time, and my client's been in jail this entire time. We have filed a justification motion that is pending, and whenever we can get that heard, that would, my client is anxious to have that motion heard. I would say I would ask, if there's an extension in discovery time, I'm not opposed, but I'd like a bond. My client has been in for quite some time, and he, has a family and he supports them, and I think in this case he should have a bond, and then we wouldn't have a problem with extending any time on the discovery.
Has there been a previous bond hearing on this case?
There has, Judge. It was quite some time ago. It was about 6 months ago. He tells me, as does his fiance, that he has COVID. It has not been easy on him in the jail, and he would like to get out and be with his family and hopefully get a vaccine as well.
Okay. Well, have you filed a renewed bond motion request?
We have, Judge. We filed a motion to reconsider bond.
Okay. Well, let me hear any argument the state wants to make in response to the request for setting of a bond.
Your Honor, it would be the state's position that based on the renewed motion for bond, there has been no change in circumstances that would affect the IALA factors in which Your Honor used to deny bond the first time, as well as the presiding judge before this case was indicted also used to deny bond. So we would request that the renewed motion for bond be denied. If Your Honor is contemplating, I guess, the giving of a bond due to the circumstances, the state would just request that before Your Honor does that, we can set a hearing so I can make sure that the victims are present, or the victims' families are present, so they can address the court about bond and why they are adamant that they should not receive a bond. Nothing further from the state.
All right, so for today, I'm going to grant you 60 days, as you request, Mr. Abadi, to get the remaining items of discovery. If you'll prepare an order in line with the ruling, identify the 2 things that you've indicated, well, 3, I guess, if the swab's considered separate from the comparison, and any report from the GBI or whoever's doing your DNA analysis, and then the phone dump by the GBI that needs to be accomplished within 60 days.
Yes, sir.
And include within the order, if there's any additional motions that the defense wants to file that are specifically triggered by the late produced discovery, then the defense will be given 10 additional days after that 60 days has run to file any motions, but that's just as to any late produced discovery on the 3 items that we've discussed today.
Yes, sir.
I will consider your motion to reconsider bond after I take a look at the transcript from the past bond hearing. May simply issue an order if I'm going to deny it after reviewing it. Then I may just issue an order denying it. If I'm considering granting a bond, I'll set a hearing date so the state can give notice to their victims.
And Judge, do we have a date for our justification defense motion?
I'm going to have 1 hearing day on this, so we will set it timely, but it'll be after your 10 days run from the 60 days.
Okay.
Okay. Just so we're not bringing him over unnecessarily for multiple hearing days, especially in the world we're living in right now.
Understood, Judge. I understand.
All right. Anything else for Mr. Thornton's case?
Nothing from the state, Your Honor.
When do you want to get your order to me, Mr. Abadi? Ask for what you need.
I can have to do the latest the next Friday, but I'll probably have to do Tuesday.
Next Friday's time. All right. Thank you. You're excused.
Thank you.
Thank you, Judge.
I'm good. Thank you, Judge. Thank you, Brian.
We'll talk. I'll come down there.
Yes, sir.
Next, we have Mr. Gilbert.
Thanks, you too. Ms. Besa, this is your case to offer the state?
Yes, Your Honor.
All right, and I believe Mr. Hudson's on for defense, correct?
Hey, Judge, I am. How you doing?
I'm well. I haven't seen your face in a year.
Yes, Judge. Well, you actually saw me, Judge. We had court in May.
It
I
seems
mean-
like a year.
Yes, yes.
You doing okay?
Yes, Judge. Ms. Basin and I got a negotiated resolution on this case, unlike the other Mr. Hudson case. All right.
The other Mr. Hudson, not to be confused with the other Mr.
Right.
All right, so you ready to go?
Yes, Judge, we ready.
Let me get caught up. Let me get the indictment. Do you have that or do I have it?
Judge, and I'm gonna ask that you sign my name, Judge, in lieu and my client's name. It's gonna be 5 years probation to both counts to run concurrent. I know that's the gist of the plea.
Okay.
Okay.
Give me just a minute.
Okay.
And Mr. Gilbert, how are you doing?
Well, how are you, ma'am?
Doing well. So we are on the record, sir. In your case, it's accusation number 21, SC 177317. You're charged in this indictment with 1 count of aggravated stalking and 1 count of battery family violence. I'm holding up the indictment right now. I'm in an open courtroom in the Fulton County Courthouse, courtroom 8B. Everyone else, though, is participating via video conference, including you from the jail. So I'm going to start by going through a few questions with both you and your attorney about your right to be present in court, whether you waive that right, whether your attorney does, and whether I can sign the indictment for both of you, indicating what your plea is today. But let me first swear you in so that everything that you tell me is under oath. Raise your right hand. Do you swear or affirm that all the statements and testimony that you will give the court in today's hearing is true and correct and based on your personal knowledge? Okay, lower your hand. Make sure you speak up nice and loud so we can hear you. So, Mr. Hudson, first of all, I have the original indictment in court. Do I have your authorization to sign the indictment on your behalf as counsel for the defendant?
Yes, Your Honor.
All right, Mr. Hudson, have you discussed with your client his right to be present and that today's hearing was set to go forward by video conference? And does he waive his right to be present and agree to go forward on video conference today?
Yes, he does, Your Honor.
All right, Mr. Gilbert, let me ask you those questions as well. Can I sign the indictment on your behalf indicating a guilty plea and signing your name here?
Yes, Your Honor.
And do you understand that you have a right to be present today in court for this hearing?
Yes, Your Honor.
And have you discussed that with your attorney?
Yes, Your Honor.
And do you waive that right and agree to go forward via video conference from the jail today?
Yes, Your Honor.
And Ms. Besa, do I have your authorization to sign the indictment on behalf of the state?
Yes, Your Honor.
Mr. Gilbert, state your full name.
Kobe Devon Gilbert,
Spell your first name.
CECOBIUS.
Secobius?
Yes, ma'am.
All right. And spell your middle name, Devon.
DEVONE.
Okay. So there looks like there might be a misnomer with his middle name on the indictment. Mr. Hudson, do we waive that?
Yes, Your Honor, and any other defects that you may find.
All right. Mr. Gilbert, what is your date of birth?
10/30/1994.
10/30/1994, is that correct?
Yes.
You need to speak up.
Yes, Your Honor.
What's your current age?
26.
How far did you go in school?
GED.
Before getting your GED, what grade did you complete?
11.
Can you read and write English without any problem?
Yes, Your Honor.
Is this your attorney on the video conference with us today, Mr. Jacoby Hudson?
Yes, Your Honor.
Have you had an opportunity to talk with him about this case?
Yes, Your Honor.
Has he gone over the accusing document with you so that you know what you're being charged and how you're being charged in this document?
Yes, Your Honor.
Has he described for you that you have the option of entering a not guilty plea and going to trial, or entering a guilty plea and being sentenced today?
Yes, Your Honor.
Do you understand those options?
Yes, Your Honor.
Do you need any additional time to talk to him today before I consider taking your plea?
No, Your Honor.
Have you been satisfied with his representation of you so far?
Yes, Your Honor.
Are you currently under the influence of alcohol or drugs?
No, Your Honor.
Do you have any prescription medication in your system?
No, Your Honor.
Have you ever had any mental health illness treatment or diagnosis?
No, Your Honor.
Has anyone threatened you in any way or promised you anything to try to talk you into pleading guilty in this case?
No, Your Honor.
Has Mr. Hudson gone over with you the rights you have and those that you would be waiving if you entered a plea of guilty in this case?
Yes, Your Honor.
Sir, I'm going to be a bit repetitive and go over a number of them again. I always do this before I entertain your plea. I'll go over the rights, ask if you understand them. I'll hear from the state's attorney. I'll hear from your attorney. And then I'll come back at the end and ask you officially what your plea is. It would be you entering a plea of guilty at that point that would waive these rights. Do you understand that?
Yes, Your Honor.
Sir, do you understand? Well, let me just tell you, you have a right to maintain a plea of not guilty and go to a jury trial where you have the right to be represented by an attorney. If you cannot afford an attorney, you have the right to have one appointed to represent you at trial. At trial, you have a right to be presumed innocent of these charges unless and until the state can carry its burden of proving its case against you beyond a reasonable doubt. At trial, you have a right against self-incrimination, which means you have a right to remain silent at trial. You, though, would also have a right to testify at trial. So you would let the trial judge know during trial if you wish to remain silent or testify, and you'd be afforded whichever of those two rights that you choose. You'd also have a right to cross-examine any witness that the state puts on the stand to testify against you. You'd have the right to subpoena and bring into court your own defense witnesses to testify for you. You'd have the right to admit into evidence any relevant admissible evidence in defense of your case. Mr. Gilbert, if you decided to go that route, that would be maintaining a not guilty plea and going to trial by jury. If you got a verdict from that jury that you then wish to appeal, you would have the right to do so and to be represented by an attorney at the time of your appeal. If you could not afford an attorney at the time of your appeal, you would have the right to have one appointed to represent you during the direct or first level of your appeal. However, sir, if you enter this plea of guilty and I accept your guilty plea, then you're waiving all of these rights. Do you understand that?
Yes, Your Honor.
Mr. Hudson, do we still have you?
Yes, Your Honor.
Okay. Mr. Gilbert, I also need to advise you that if you're not a U.S. citizen, entering a plea of guilty will impact your immigration rights. Do you understand that?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
I also need to advise you that if you have any other open cases that we are not resolving today, or if you pick up any cases in the future, you will have today's conviction on your record, and that could affect future sentencing in those type of cases. Do you understand?
Yes.
Sir, I also need to advise you that if you wish to challenge today's guilty plea for constitutional violations by filing a habeas petition, a separate suit, you need to file your habeas petition within 4 years of any felony conviction, within 1 year of any misdemeanor conviction. Do you understand?
Yes, Your Honor.
All right, Mr. Gilbert, at this point, we're going to hear from Ms. Basa on behalf of the state. She's going to go on the record with the sentence range available to the court, the facts of your case, any conviction history she has for you, and what the state recommends on sentencing today. Then I will hear from Mr. Hudson on your behalf. Ms. Basa.
Thank you, Your Honor. The sentence range for count 1, aggravated stalking, is 1 to 10 years. And the sentence range for count 2 on the indictment, battery, family violence, is 1 to 5 years. If the people had proceeded and gone to trial, the state would have expected its evidence to show that on August 4th of 2020, at approximately 1:24 p.m. at 1700 North Side Drive in Atlanta, Georgia, Officer Errol, E-R-R-O-L, Howell, responded and spoke with Miss Andrea Copening, Copening. Miss Copening and Mr. Gilbert are husband and wife. Miss Copening told officers that her and Mr. Gilbert engaged in a verbal argument while inside of her bedroom because he confronted her about a male that he saw leaving the apartment. Ms. Copening told the defendant that the unknown male is a friend of her sister's. The defendant did not believe her and told her that he was leaving. The defendant walked to the door, put on his shoes, and realized he's left his phone in the apartment. Ms. Copening told the defendant to not walk on the floor with his shoes as their 11-month-old child crawls on the floor. The defendant then pushed Ms. Gilbert out of the way. Ms. Gilbert held onto his dreads in self-defense because after being pushed, and then the defendant punched Ms. Gilbert in the right eye, causing a bruise to her eye. As I mentioned before, at the time of this incident, they were legally married, but I failed to mention that they were living in separate locations. As to the aggravated stalking, there was an order in place of a court which prohibited any kind of harassing and intimidating of Ms. Andrea Copening. The state does not have any felony criminal convictions for Mr. Gilbert. I've spoken with Ms. Andrea Copening. She stated to me, I spoke with her earlier this week, and she stated to me that she is not scared of her husband, the defendant, and that she is comfortable with contact with him. I told her as part of the plea recommendation, there'll be no violent contact, and she's okay with that. She does want contact with him. So the state's recommendation on this case for count 1, aggravated stalking, plus 5 years probation, plus the Family Violence Intervention Program, plus no violent contact with Ms. Andrea Copening. And count 2, battery, family violence, plus 5 years probation to run concurrent with count 1, plus the Family Violence Intervention Program, plus no violent contact with the victim. That is it for the state.
All right, thank you, Ms. Besa. Let me hear from defense, Mr. Hudson.
Your Honor, the facts as Ms. Besa pointed out are accurate. We just dispute the fact that my client did not punch Ms. Gilbert. He actually kind of what they call mushed her in the face, and she's a she has fair complexion skin, and so that's what a bruising happened. But everything that Ms. Besa pointed out is true. My client, also Ms. Gilbert, she has, I spoke to Ms. Gilbert as well as the state. She also wants no violent contact. We want Mr. Gilbert to get all the treatment with the Family Violence Intervention Program. He also been in continuous custody too, Judge. So I see it maybe almost either 5 or 6 months. I don't know how many days in, but I know it's well over 120 days. Also, Judge, Ms. Gilbert is actually 9 months pregnant. She's in the hospital her labor is about to be induced. So Mr. Gilbert and her are expecting a daughter at any minute now. So Judge, we ask that you take the plea. My client was working, Judge. He's was providing for the family. They've been married for almost more than a year now. And so they welcome in their first child together. So Judge, we ask that you follow the terms of negotiated resolution. Give Mr. Gilbert an opportunity to make things right with his wife, as well as be there for their soon-to-be daughter. Also, Judge, I think that Mr. Gilbert, we went up for a bond hearing. His bond was initially denied. That was a good thing for him, Judge, because he needed to sit down and reflect on that fight that he had with Mrs. Gilbert. So I ask that you take the terms of negotiated resolution. And there was a court order in place too. Let me address the aggravated stalking, Judge. Judge, there was a court order initially in place between them. Ms. Gilbert wanted contact, so my client violated that order by coming back around his wife. And that's why we're here, Judge. So I ask that you just follow the terms of the negotiated resolution.
All right, thank you, Mr. Hudson. Mr. Gilbert, I need to hear from you. What is your plea to the 2 counts in this indictment? He's on mute at the jail. All right. What's your plea to aggravated stalking and family violence battery?
Guilty.
I accept your guilty plea. I do find there's a factual basis to support it, and that you're entering today's plea freely and voluntarily with full knowledge of your rights and those you waive in entering that plea. I will agree to sentence you to the total of 5 years probation. That's 2 years probation, count 1. Is that right?
No, Judge, I believe it was 5 years per count on each count.
That is correct.
I don't know where I got 2 years. 5 years on each count to run concurrent on probation. Conditions of your probation, you must complete the family violence intervention program. That must be completed within 6 months of you starting your probation. So make sure you complete that. If you haven't completed it in 6 months, then probation can have a warrant requested for your arrest. Do you understand, Mr. Gilbert?
Yes, ma'am.
An additional condition of probation is to have no violent contact with the victim. Violations can be handled through POM up to the full extent of the law. Anything else for the state?
No, Your Honor.
Anything else for defense?
No, Your Honor.
We'll get that Senate sheet signed today. Thank you all. You can be excused. Oh,
Thank you, Your Honor.
sorry. Not yet. Ms. Brown is on for probation. She needs to give reporting instructions.
Yes, I need the county that the defendant resides.
14.
Okay, the defendant will report to the 276 Memorial Drive location, Southwest Atlanta, Georgia, 30303. The day will be March 25th, 21 at 8:00 a.m. Failure to report on that date and time result in a probation warrant. I do need an updated address and contact number for the defendant. If that could be forwarded to Ms. Little in the near future by counsel, that'd be great.
I will, Ms. Brown. Thank you.
Nothing further, Your Honor.
We can hear you a lot better. Thanks.
Thank you.
Which computers?
Also,
Thank you, Judge. May we be excused?
you can. You're excused. Yes.
That is mine.
All right. I got your note. Hold on, everybody. Hold on, Ms. Brown. Okay. All right, come on up, Mr. Hudson. So, Ms. Besa, Mr. Hudson is here, other Mr. Hudson, on Dante Hudson on the Melvin Mims case. He needs to go on the record to just clarify that Mr. Mims was not on probation at the time of the alleged offense, which I didn't take it that he was. I think, let me just hear what you have to say, if I'm understanding this note. But
Yes, sir. Thank you.
we're back on the record. It's State versus Melvin Mims, 19 SC 170584. We have Ms. Besa for the state and Mr. Dante Hudson for defense. Yes, sir. Go ahead.
Thank you, Your Honor. I'm unable to access Odyssey, so I don't have the exact case numbers, but
I can get it. Hold on. So the one that I have that we made reference to during his sentence and that we handled as a revocation, I see what you're saying, is 19 SC 167826. And that's the one you want to address?
yes.
Okay, go ahead.
Thank you, Your Honor. I believe the court revoked Mr. Mims' probation in that case. At the time that Mr. Mims pled in the 19 SC 167826 case, the case involving the case where he pled today was already pending. That case was from 2018, August of 2018. And so as such, because that offense predated his probation, that would not have resulted in a probation violation.
Okay. I see the issue, and it was today's case, 19 SC 170-584, has an incident date of August 17, 2018. And while he has a 19 SC 167-826 conviction, on the conviction date was September 27, 2019 for an offense that was May 2nd, 2019. So I think you're absolutely correct that the new violation that for which he was convicted would not have been a probation violation of the 19 SC 167-826. That's what you're saying?
Yeah.
Okay. So I don't think the court needs to enter any kind of order and make a finding. I'll make a finding on the record that that's not a violation, and so he won't be revoked on that case.
So that goes into a reconsideration of the first sentence?
No, they were handled separately. I mean, it was a sentencing on the offense that was before the court today, and I agreed to run concurrent a sentence on the revocation so that that was handled and he wasn't getting additional time for that. But there's no grounds to revoke him at all on the probation case that for the reasons you stated. So there's not going to be an order revoking him on that.
Yeah, no reduction.
I've already answered that. They were handled separately. Recommendations were made on the open case, on the new case. Sentence was issued on the new case. The probation case was handled separately from that, and I agreed to run it concurrently. So I didn't add any time because of the probation case for the current case, and vice versa. I was running it as a concurrent sentence. So no.
Thank you.
All right. Anything else for the state on that, Ms. Besa?
No, Your Honor, that's my last case. May I be excused?
Do you agree or disagree with that? I didn't even give the state an opportunity to be heard on that, but it seemed clear to me that Mr. Hudson was correct on that not being a proper revocation.
It is very clear as the time of the incident predates the actual conviction of the 19 SC case.
All right. Did probation wish to be heard on that at all?
No, Your Honor, I concur.
All right. And for the record, we have Mr. Mintz back. He's on the video conference. I didn't indicate that. All right. Anything else, Mr. Hudson? All right. You're excused.
Paul. I guess I'm still at 5 years.
May I be excused, Your Honor? That's my last case.
You can. I think that's it for all of us. Thanks, Ms. Brown. You can be excused as well.